Okay, everybody, we're here for another property virtual lecture, and we're in property 7. Now we're going to do a little bit of a review on contracts, and then we're going to move into real estate contracts. So that's what that R/E means. So property 7, contracts review, real estate contracts. So this is very ambitious. I'm probably going to have to break this into 2 because there's just a lot of information on these, but I just do want to hit a few of the contracts high points from last week, and then hit how it all comes together in the real estate contract. So look for about 2 of these. We'll call this one number 1, okay? So we'll put a Roman numeral 1 here, all right? Now, let me get my notes here and talk to you a little bit about what we're dealing with. One thing you want to keep in mind on contracts is that we need to understand what are the requirements for an enforceable contract. And so basically what you're getting into is, all contracts have basic elements regardless of what they're for. You might be buying a dryer, you might be having your house remodeled, you might be buying a car. There are certain basic elements that are required in every contract. And so those translate into buying and selling of real estate. So that's going to be something that's going to be important when we pull all this together. Main 3 types of things that you want to look for is, that there are different types of contracts, like we said. There are real estate agency listings, for example. Then there's obviously offer to purchase. We often call that an OTP or OTP, offer to purchase, okay? Also, you've got to understand that every one of these sales of real estate has tax consequences. For many years in Indiana, they had a rule that went, well, if you just put $1 and other valuable consideration on the deed, then it keeps people out of your business. Well, the IRS kind of objected to that, and the Indiana Department of Revenue, because basically they're saying, well, what did you really pay for this? Because what they were doing, they were seeing a lot of money laundering going on in different kind of gambling activities, even drugs, and so they're trying to trace the money. So they've really tightened up on that. So there is a form that you have to fill out in order to make sure that it is in fact sold for a set amount of money. It does not get published to the public, but it is available to the IRS. But on the deed, then, you can still say on the deed $1 and other valuable consideration. Well, a contract is defined as an enforceable agreement between 2 or more people consisting of a promise or mutual promises. This is for a valid real estate contract to exist. There are many legal requirements. If these legal requirements are not all met, then it is unenforceable. One of the things we talked about in another class is, there's certain time deadlines. So if someone makes an offer, the other person is under a time deadline to reply. If they fail to reply, then the offer is rescinded. Likewise, if you make an offer and then the other person makes a counter offer, then you have to sign that counter offer or make a second counter offer within a time period. And the case that we were looking at was a case where the basically buyer was stalling around and ran past the deadline, so the seller sold the property to somebody else. So they were like an hour late in turning in their paperwork, and as a result, they sold it to someone else. Of course, litigation ensued, but the court said basically, hey, you've got to live up to all the requirements. So basically, requirements of contracts generally are legal capacity, which means that if you are mentally ill and under a guardianship, you cannot engage in a contract. If you are 16 years old and you want to sign a contract to buy a house or car or something, you can't do it. You've got to be over 18 years old. There has to be mutuality, which is to say both parties have to agree on all the terms, so that's very important. There has to be some kind of consideration. it is a form of mutual consideration. So I make an offer to sell and I give you $500. You agree to sell it under circumstances that you will close within a certain amount of days, and you're making certain warranties that it's a good house, that you've got good title, that you really own the house. So these are the type of things when we're talking about consideration. There has to be a lawful purpose. You cannot, for example, sell a house to your brother to avoid having to include it in your bankruptcy. There has to be a written agreement. The statute of frauds requires that all real estate transactions have to be in writing, except for week-to-week leases of less than 1 year. So anything to do, leases, even long-term leases, sales, contracts, anything like that, has to be in writing when it comes to real estate. Legal capacity, going over that again, they have to be able to follow through. The two main categories, again, like I said, minors or infants cannot sign contracts. Mentally impaired or mentally incompetent people cannot sign contracts. Now, if someone seems to be acting a little odd to you, might call for some more investigation, but it does not necessarily mean that they cannot engage in a contract. They have to be like certified as mentally ill by a doctor, and that has to have been filed in a court, and the person is subject to a guardianship. Because just like if we said, well, he's a little bit off, well, everybody's a little bit, you're the only normal person, So there has to be a standard. The standard is, well, some judge had to say that they are mentally incompetent, so they can't engage in any kind of contract. Only their guardian can sign the papers, not the principal. Okay, corporations. There still has to be signature by some humans on behalf of that corporation. And they have to have what they call the apparent authority to sign that contract. The apparent authority is usually proven by some kind of a corporate directorship, signatures by all the members that say, yes, we've designated Joe here to be the person that signs these contracts for the corporation. And when we say apparent, it has to look valid, seem valid. If you want to follow up, call the corporation and you got this guy, that guy, this guy working there, yes. Did they sign a paper saying that Joe's in charge? Yes, yes, he is in charge. He can make those deals. Other requirements, legal capacity. This involves partnerships. Any general partner can bind a partnership. Now the limited partners cannot bind a partnership, only the general partner. Okay, another thing, limited liability companies, we're just talking about that in business class. Manager or any member of a limited liability company can sign. So that's a major difference between partnerships and limited liability companies or corporations. Personal representative, that could be like the executor, some type of fiduciary who could sign on behalf of an estate. They have to have papers from the court, once again, saying that they have the authority to do this and they cannot act in violation of the will. So in other words, if the will says, my house goes to Jill, and then so the executor is trying to sell the house, can't do that unless there's a court order that says, well, you can sell this property because the estate doesn't have enough money to pay the bills. So even though it was his plan to give it to Jill, you got to pay the bills first. So valid contract can be done by trustees in bankruptcy, for example. They are very similar to executors. They have to get approval from the bankruptcy court. Legal capacity to contract, again, you can have agents, which are like people with attorney-in-fact or power of attorney. They can contract for their parents. If it is a durable power of attorney, that means it can never be revoked. So even if the person is mentally ill in that situation, like Alzheimer's patient, the POA or attorney-in-fact can still sign on their behalf. But they would probably want them to attach a copy of their court order that says they have the right to do that. Another requirement is mutual agreement, and that's meeting of the minds. So basically, if it's all not written down and you guys made certain agreements, well, I'll leave the stereo, that doesn't count. There's no meeting of the minds on the stereo because it's not mentioned in the contract. The seller can take that stereo because that's personal property, not fixtures. Now, on the other hand, you sign a contract that doesn't say, well, I get to keep the water heater, the buyer keeps the water heater. Well, you don't have to do that because, as we know, water heaters are fixtures. So here again, mutual agreement. The acceptance must contain the same terms as the counteroffer. In other words, you have to finally come to what we call a meeting of the minds so that both offers are consistent. If there's one you finally like, you just sign it. So basically, if you sign it on the real estate contract, then you've got an enforceable agreement. If it's timely. Now, once again, I had a case here a while back where a guy signed it, but he signed it after 5 o'clock, and the deadline was 5 o'clock. Remember the requirements, that there has to be consideration, like money, and then it has to be bought for a lawful purpose. You can't be buying it to run an illegal, let's say, house of prostitution in there, or gambling casino when it's illegal. Requirements of a valid contract also include, like I said before, the statute of frauds. You can sign, for example, to answer for the debt of another. You can obligate your property to help one of your kids pay off their bills, for example. Agreements in consideration of marriage, not favored, not favored. So in other words, I'll buy you a new house if you'll marry me. And they don't like that. That's not good, you know, because it's kind of a form of indenture, what we call slavery. Agreements cannot be performed in 1 year, have to be in writing, okay? Contract for sale or transfer of any interest in land. If you're splitting it, if you're leasing it for like 99 years, anything like that, more than 1 year long, then it has to be in writing. One thing you've got to know is that there are instances where oral real estate agreements can be enforceable. Now, this is very unusual, and that is because, here again, it's not favored. But let's say you make a handshake agreement and the person starts making major changes to this property. They pave the driveway, you know, they paint the whole outside of the house, you know, things like that. Then, you know, that's what we call partial performance, and we have a form of detrimental reliance. So I'm going to put detrimental reliance on the board because basically, to the buyer's detriment, he went in and paved the driveway, okay? So, you know, that is the kind of thing that shows that the parties had to have some kind of a meeting of the minds. And so remember, we say, we call that part performance, okay? So part performance is an equitable form of contract. So that is a contract in equity, we call it. And what they basically do, they're applying a contract where there wasn't one in writing. And so basically, you know, you've got to watch out for these equitable solutions. Most of these things that we read or that we talk about come from the legal side of the house. But there are some instances where we look to equity to solve some of these problems. And you know, the word equity, I'm sure you've heard of. Well, how much equity do you have in your house? Well, what that means is you don't really have anything in your house except you've paid this much off on your mortgage. So your bank knows and you know that you have equity in your house. Well, equity means under no circumstance are you to walk away from that house without some kind of money. Well, written contract has to have the parties' true names and agreements to buy and sell. Basically, these contracts have to have a clear description of the real estate, a price, any kind of terms of payment, like so much down, so much a month, or it could be like $500 down, pay the whole thing off in 30 days. Also, the earnest money, sometimes it'll say Well, even if you're unable to get financing, the seller gets to keep the earnest money as damages. Other times it's saying that the buyer gets the earnest money back if they cannot come up with a loan. Also, the contract must have a date of closing. That means when the whole deal is going to be done once and for all. And then it usually has the term time is of the essence. What that means is to hold everybody's fingers to the fire so that they will get their part of it done. There are also pre-closing conditions, which are, you got to fix the roof. Okay, I'll fix the roof. Signatures, everybody has to sign it. Well, what are the remedies for breach of any kind of a contract? We have several. One of them is specific performance. You just put the roof on and I'll go ahead and buy the property. Okay. Money damages. You can say, well, I was really counting on that, especially in a business property. I put that money down for a reason. I need that. You're messing up with my business. You're going to cause me to lose money because I need to get this hamburger stand open right away. Rescission. If it's in the buyer's interest to say, well, the deal's off. You lied to me on a bunch of different stuff. Lying on the terms as far as, yeah, this is a good house, or I've got warranties to sell it. You may just want to walk away from it. Another thing is like liquidated damages. A lot of times parties do spend some money on title searches and things like that, attorney fees, and so you can get sometimes liquidated damages. Specific performance we mentioned earlier. Basically it has some unique thing that needs to be done, and if they do not have another adequate remedy, like, well, we'll just take $3,000 off the price, you can have your own roof put on. So that's another option. Basically, courts can order both parties to follow through. Can be limited to situations where the contract is clear and there's no fraud or mistake. So the court can say, yeah, go ahead and finish this contract and quit your quibbling. Remedies, other remedies, money damages. It would be the difference between the contract price and the market value of the real estate. So if the value of the price of the house goes down and you find out, well, there's all these bad things wrong with it, so the price goes down, then they will do a reduction in the contract price. Other remedies, you can rescind, like I said. You can just close out the deal, say, I'm not doing it because you lied to me. Basically, the liquidated damages are reasonable. Sometimes they can be set out, like all closing fees, including title searches, and that type of thing will be paid for by the buyer. One thing too about brokers, you got to watch brokers, because the problem that you get into is that sometimes brokers want to walk on both sides of the street. They basically can represent both parties, but only if you agree. Both parties have to agree. I don't recommend it. I mean, I think they'll try to talk you into it because they get more money if they do that, but I don't think it's in your best interest ever to have the same person represent both parties. I don't care if it's a lawyer in a divorce or a realtor in a land sale. One of the things too on that is that there are people called realtors. A broker is a realtor, but only if they are a member of the National Board of Realtors and a local Board of Realtors. It's a designation that you have to earn through experience. You can be a broker, and that's fine, but if you really want to be a realtor, then you have to do this for a good long while, pass some other tests and so forth. And so there's such a thing as a broker's license, and then there's a realtor membership or certificate. So those are two different things, but realtor is a broker, but a broker may not be a realtor. Agency relationship, real estate broker has a duty to his client. That's why there can be conflicts that'll crop up, and so that's where you need to really be careful and avoid where you have seller's broker be the buyer's broker, or you shouldn't even have two brokers in the same company or business. You should go to another company. Other things that brokers do, they can have a lot of list of names. People can make some small repairs for a reasonable amount of money. They also have connections with the title companies and so forth. One of the things I'd mention to you is when I lived in Ohio, lawyers handled all this, and the broker had a really small part to play in it. In Indiana, the broker has just pretty much taken over the whole thing. Lawyer has just a tiny little part to play and doesn't really get much involved in any kind of real estate dealings other than to prepare a few documents for just a very few dollars. And that, I think, is a disadvantage. Even though it's a little more money, it's about $850 to $1,000 to have a lawyer oversee the actions of the realtor. But generally, between the two of them, you know, it'll come out good. Whereas if you just have a broker handle it and he's representing both parties, they'll say you'll save money. You do save a little bit of money, but you know, you're looking at something, investment that you're going to make over the next 30 years. So it's pretty important, in my opinion, to you know, involve a lawyer in it in the early stages, even if it does cost a little bit more money. Because you're buying a $100,000 house, let's say, and you know, you're afraid to spend another $1,000 to make sure that you're protected and you're not getting ripped off. So those are the type of things I think that people fail to think about. Well, listing agreements, the owner hires an agent, they sign an agreement, they have the right to hire other agents, but basically that's pretty rare. Again, you get into a lot of expense when you go that route. Usually it's exclusive. The owner only hires one agent, and it'll be set out that way in the listing agreement. You're not allowed to go shop for another agent unless you can see that the person is not being effective. They've had it for a period of time. Usually there's a pretty short expiration date on these listing agreements. If they don't find a buyer in that time, most people would probably be smart to move on. Sometimes the owner can reserve the right to sell property, especially if they have a list of names of people that they know are interested in the property. Some of them they have, though, that, hey, I've just got to have a free hand. Anybody you've talked to, let me talk to them and see if I can get them interested. One thing, too, is a new concept is realtors and the internet. They're listing properties all over the country, and really that can be good for a seller because you're getting a lot of opportunities there. Also, think of the tax consequences. That's another important thing. And so let's not forget, you might even need to see an accountant depending on the amount. Now let's say this is a family farm. It's been in the family for a bunch of years, but nobody wants to farm anymore. There's 4 or 5 kids or heirs. You know, you need to talk to a CPA about the tax consequences of the sale of this property, because there could be taxable returns for you. And what's the basis in the real estate, for example? Accountants can help you a lot with that. Lawyers just know that there is such a thing. Accountants know how it works. So it could be important. And here again, a lot of real estate's going for, you know, like $10,000 an acre now today. And so if you had 100 acres, you know, what is that? You know, I can't even do that math. Is it $1 million or what is it? Well, anyway, whatever it is, you know, it's worth it to find out how this is going to hurt you in terms of taxes. Well, one thing to keep in mind is commercial property is really different than a home. Homes, you have certain rights to buy another home and transfer your basis from the one home to the other home. Commercial property, usually that doesn't apply. They have depreciation on the commercial property. So basically what you end up doing is that you basically, if you depreciate the property, your basis sinks, and so then you have to what we call recapture depreciation in a commercial real estate deal. So what that means is if you got something for commercial use, even a rental property, you fully depreciate it down to zero, then basically when you go to sell it, you're selling it for the full price and you're going to have to pay taxes on the full price. And you know, that could be, you sell it for 60 grand, you bought it for 45, you would think, well, I just pay taxes on the profit, 15. No, if you actually depreciated it, then you're going to pay on the full 60. Okay, well, client funds, basically These are very bad if people are not handling them correctly. Ethics, like we talked about, trying to co-list people. Contracts are termed by the authors of your book as the legal glue that binds people together in a real estate contract. Basically, again, remember, legal capacity, no kids, no mentally ill people under a guardianship. There has to be a written offer and acceptance. There has to be some kind of consideration. And then there has to be a lawful purpose. Can't use it for basically house of ill repute or a gambling place because it's illegal. And then everything pretty much needs to be in writing. Keep that in mind. If there is a default in the contract, the non-defaulting party has certain remedies. These include damages, liquidated damages, rescission, specific performance, and recovery. Basically, brokers can represent the buyer or the seller or both with written consent. I do not recommend it. So if you're ever in that situation, don't do it. It usually comes to a bad end. Okay, basically, realtor's job generally is to protect the client's interests. That's true of a broker. So those are the main points I wanted to cover. This, again, is just kind of a refresher on the contracts. We'll come back later in the week, and we'll have another presentation on more details on real estate contracts. Thanks for watching. We'll be back with you later.